car crash cases, injuries, and abuse. Across the state of Alabama, the attorneys of Hollis, Wright & Couch are here to serve you. With civil trial lawyer Josh Wright from the firm of Hollis, Wright & Couch and Alabama's 13 host David Lamb, the attorneys answer your tough legal questions straight ahead.
Hello and welcome to the Attorneys, where your tough legal questions get answered. Tonight you're going to get the opportunity to hear from an expert panel, and you get to contribute. All throughout the show, you will notice on the screen ways for you to call, text, or email us, and we absolutely would love to hear from you and get to your question tonight. We're joined, as is often the case, by Josh Wright of the firm Hollis, Wright & Couch. Good to see you, sir.
You too. Hope you had a good week.
Indeed it did. Absolutely.
You know, David, this is an issue. Over 500,000 families in Alabama rent their premises.
Right.
And so it's something that is significant and a real issue that folks face. When our firm has issues related to landlord-tenant law, it can be a very simple law, but it can also be a very complicated law. We go to folks like Shawn Pryor at the Cochran firm. She knows this law in and out, does a very good job on these type cases, and so we wanted to bring her on. We're excited to have her here to help answer questions related to something that affects so many in our community.
Shawn, good to see you. Thanks for being with us.
Thank you.
Let's, if we can, kind of start with an overview and a launching point. When we talk about landlord-tenant law in Alabama, what exactly are we talking about?
Well, we're essentially talking about landlord obligations and tenants' rights under the landlord or the Alabama Landlord-Tenant Act.
Mm-hmm. So is there anything that a potential renter should do before they actually enter into a lease? Kind of walk us through what we should be thinking before we actually do that.
Sure. What a tenant would want, or a potential tenant would want to do, would be to investigate the property that they plan to rent. They would want to go to the home and look at, make sure that the appliances work, make sure that the place is in good repair. If it's an apartment complex, for example, they want to make sure they look at the exact unit that they plan to rent as opposed to the model unit, and make sure that the plumbing works, that there's no cosmetic repairs that need to be made, and just make sure that the place is in good order before they decide to sign a lease.
And a tenant, David, has got the right to do that. I mean, they've got the right to go and look at the actual premises that they're going to be living in as they're signing the lease to make sure that it is what they bargained for and what they're expecting.
Yeah. So if they take you to a model and not the one that you're actually going to be renting, you could say that this looks fine, but I would like to see the one where I'm actually going to be living in.
Yes, definitely.
Okay, and they have to do that.
And you'd recommend that?
Yes, I would recommend that, sure.
All right. A question, we love the questions that come from our viewers, so please be sure to chime in, because we'd love to get to your question. But a question we've got here, during the inspection of a home or apartment that you're going to rent, what should you do to find if something is wrong with it? Like what, are there any sort of things you should do from that standpoint?
Sure. You want to make note of any type of repairs that need to be made, make a listing of them. Sometimes with apartment complexes in particular, they'll give you a list that you can go by and check off things that you need to look for. But you would definitely want to make a detailed list, go room by room, and make sure that the make sure that the repairs that you think need to be made are listed. You would then want to take the repair list to the landlord and address those, and request in writing that the landlord make those repairs prior to moving in.
When cases and issues get to you, what are some of the common mistakes? Is it a couple of times you've mentioned kind of be real deliberate on the front end? Oftentimes are those mistakes we rush through that, or take things for granted, or don't know exactly what our rights are and what we're capable of asking for?
In my experience, yes, I do think people rush through that. Sometimes they're in a situation where they have to go ahead and rent someplace, so they don't take the time to make sure that these things are taken care of. And in addition to that, I find that people are a little less formal about that, and they trust the landlord. And a lot of times that will bite them, at the end when they're trying to get necessary repairs made.
Yeah.
When you also find out, I think, and Shawn, correct me if I'm wrong, but if you don't document things on the front end, when it's time to move out, if you put a security deposit down, for example, and you want to move out, there may be a condition that pre-existed the time that you signed the lease that you never raise to the landlord, and the landlord thinks that you caused that problem, and it can have an impact on your security deposit, can it not?
It can. In fact, the landlord has an obligation within 35 days after you move out to give you an accounting of all of the of that deposit and what they're going to take out with regard to repairs or damages that they think you've done. So it's very important to make sure that you notate any repairs so that you're not held responsible at the end of that lease term.
Sean, didn't this law change in the last 4 or 5 years? Isn't there now there's a legislative code section or a code on the issue?
Yes, the Landlord Tenant Act changed in 2007, and there were some important revisions related to tenants' rights during that change.
Okay. Another question that we've got, this is about signing the lease. I think oftentimes whenever you sign something, kind of cautious about that. But what do you need to look for in the lease, actually, the document itself, before signing?
That's a good question.
Yeah. Well, the most important things are you want to make sure that the lease agreement contains what you actually agreed upon. If you intended to sign a 1-year lease, you need to make sure that it actually says 1 year. Want to make sure that it lays out who's responsible, for the landlord or the tenant, who's responsible for making necessary repairs to the home. You want to make sure that it addresses the security deposit, if there's any security deposit that has to be made. And you want to make sure you just read the lease very diligently. Leases can be very cumbersome and very long documents, sometimes several pages, sometimes 1 page, depending on the sophistication of the landlord. So you just want to make sure that you read all the fine print on the lease.
David, I think kind of the general concept here is communication with the landlord on the front end to totally understand what you're entering into is also critically important to make sure that you're getting what you bargained for and what you understood during the time that you were trying to find the apartment.
Also, moving on to the topic of tenant rights, what are we talking about whenever we discuss tenant rights?
Well, we're talking about rights that the tenant has under the Alabama Landlord Tenant Act. And some of those rights include the right to live in a habitable or livable apartment or home. The landlord cannot force you to agree to live in a place that's in disrepair and doesn't have running water or heat or things of that nature. We're also talking about the landlord cannot force the tenant to pay for attorney's fees or the cost of collection. Those are things that changed with the Landlord Tenant Act that was enacted in 2007.
And as I recall, the landlord also cannot limit its own liability for breach of the agreement. Isn't that fair?
Yes, that's correct.
And if you see those types of provisions, those are times that you want to get somebody like Sean involved to make sure that the landlord's doing it the right way.
And you know, with we've had so many awful storms here of late, and certainly last year. So if there's some sort of storm damage and something happens to your apartment, the landlord is responsible for helping you find something where there's not a big hole in the roof, kind of issue.
It's probably dictated by the lease agreement, is it not?
Right. In many cases, the landlord will actually require that the tenant will have renter's insurance that would cover those types of things.
Right.
In some cases, though, the landlord, don't they provide renter's insurance? I mean, I guess it's subject to the lease itself, but that's a question you need to ask on the front end, isn't it?
Right. In some cases, they can provide it, or in some cases, they will direct you to an insurance company that provides renter's insurance. So it's always a good thing to check into that and make sure that you have it, even if it's not required by the lease, actually.
Yeah, you recommend renter's insurance for content and whatnot?
Yes, I would.
Because of fires and all those types of things.
Right, water damage, any of those things that could happen in an apartment complex in particular.
And documenting what's in there as well?
Yes, documenting what's in there, and if you have records, maybe keeping those in a separate location, because of course if the property is destroyed by fire or there's water damage, you wouldn't have access to those documents. So making sure you make copies and keeping those someplace else would also be beneficial.
And we talked about in case of weather and a danger there and an issue with the dwelling. But what about from a safety standpoint? Is that like if you live in an apartment complex? Can you expect someone, a landlord, to have an environment that is safe and have some sort of security?
Yes, you should expect that. In fact, if it's an unsafe environment, you should definitely take that up with your landlord and let your landlord know this is unsafe, this is what's happening. And if they don't do something about that, then I would suggest that you put it in writing and give them 14 days to repair the unsafe condition, and if they don't, you need to contact an attorney and see what rights you have in order to have it correct.
So it is possible that is, if you think you're moving into someplace that's safe and you find out, surprise to you, it is not, that potentially could be worth breaking the contract in the lease that you signed?
Correct, if the landlord does not repair that problem.
Right.
Yes.
Yeah. So
Another reason why you go to someone like Sean.
Absolutely. Yeah, absolutely. Good stuff, and I think something that affects a whole lot of us. So look forward to your questions. Even throughout the conversation tonight, welcome you to be a part. These experts are here to offer you the legal expertise to help you solve your legal battles. You can contact them 24/7. Just might feature your question on the show. You can fan them on Facebook. Just search Hollis, Wright, and Couch. Follow them on Twitter as well at Hollis_Wright. Much more on this topic as the attorneys get right back.
I'm Josh Wright with the law firm of Hollis, Wright, and Couch, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. Or simply contact us by going to alabamas13.com and click on the Attorneys link. We know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on Alabama's 13.
Defective products, dangerous drugs, car crash cases, injuries.
Get to that in just a bit. Quick though, a reminder, would love to hear from you throughout the show. So if a question pops into your mind, something that you would like for me to take to the experts, just get that to us. Email, text, call it in, and we'll try to get that to them. Sean, about that firm fact about discrimination cannot be discriminated against, what steps should be taken if you think that you are being treated differently than what was called out there on our firm fact?
Well, you can contact Fair Housing and make a complaint with the Fair Housing Department, or you can contact an attorney and they can assist you in making a complaint or give you legal advice on how to handle that.
How difficult is that? I mean, must it be a confrontation, or must you have some, either words spoken or something written, something really provable? Does it have to? Is it highly difficult to prove those sort of cases?
Well, if you make a complaint to Fair Housing, they will investigate that. So if you think you're being discriminated against because you have kids, for example,
right,
they will investigate that and actually make inquiries and maybe send other people out that say, I have kids, can I rent from this apartment complex, and see what happens, and they will investigate it and make sure that that is or isn't happening actually.
As is often the case too, David, statistics help. So, sometimes you can come in and you can do an evaluation, or a lawyer can do an evaluation to see, statistically who's there, how many, different types of people that have children are there. Are they renting to people that are African American versus Caucasian more, that type of thing. So statistics help.
You mentioned, both of you mentioned a livable dwelling, have the right to a livable dwelling. The question we've got here, how do you define that? What is by definition, what is a livable dwelling?
A livable dwelling is generally a dwelling that's free of any major disrepair. It has running water, the plumbing works, the electricity works. The roof can't be caving in. I think that livable dwelling when you see it, but it has to be free of any major defects, and that the utilities need to be working and that type of thing.
Okay. Another question that we've got about raising the rent. A decision is never popular, but can my landlord raise the rent?
Well, the landlord cannot raise the rent during a current lease term, but once that term has expired, the landlord is free to increase that rent at that time under a new lease agreement.
Okay.
When you're going into a new lease agreement, one thing to look at too, David, when we get calls at our firm about this issue, sometimes the lease agreements will indicate, and Sean, help me here, but they will indicate if you don't do anything within 30 days of the end of the lease, it renews itself for a 30-day
Yes.
period. You need to kind of understand in your lease not just when the termination date is, but when the requirement that you renegotiate your lease takes place, don't you?
Right, because you may be going under a month-to-month lease after that your lease is up, for example, and that would be a higher rate than if you actually renewed at another year lease term, for example.
All right. We've talked quite a bit tonight already about what a landlord's required and kind of landlord requirements, but what about the actual tenants under the law? Are there requirements for tenants as well?
Well, tenants need to pay their rent on time. They need to keep the dwelling in good repair. They need to make sure they're abiding by the law and making sure that their guests, if the guests are visiting, that they're also abiding by the law. They can't disturb their neighbors and make their neighbors' home unenjoyable. They have to make sure that they're being good neighbors and make sure that they make use of the property as defined in the lease agreement. So if it's supposed to be used for a residential unit, then they need to make sure that it's used for that and not for any commercial use or any other thing of that nature.
Yeah, and you make that, we talk about that it can't be used for commercial use because it's residential. People don't realize that they can run into problems just, for example, if they have a photography studio that is run out of an apartment, that may very well be a commercial lease and may violate your lease. If you are running any type of business like that, it's always a good idea just to check with the landlord on the front end to make sure expectations are understood by everybody going in. For example, if you are a sales rep, a pharmaceutical rep, for example, and you're working out of your house, you're probably going to be fine. But solve the issue by talking with your landlord on the front end before you move in so that you don't have a problem down the road.
Okay. A question here about landlord and repair individuals coming and inspecting the home kind of unannounced. Is that, I mean, can the landlord come in just unannounced and barge into the apartment to make sure everything's okay or what's going on?
Well, typically the landlord has to give a 48-hour notice,
okay,
and that's usually listed or defined in the lease. Now the landlord can enter unannounced under certain circumstances, and that may be in an emergency situation.
Right.
There's some type of pipe that's burst in your apartment, and they need to get in right away, and of course they can't give you a 48-hour notice if they have to enter immediately.
Other than an emergency, though, you should not expect that in the middle of the night your landlord's just going to walk in your apartment. I mean, that's something that it should not be allowed.
Right.
And if it is and it's going on, somebody needs to solve that problem.
And even if it's a lawful entry, it has to be reasonable. If they give you 48 hours notice, they can't enter at 2 a.m. in the morning.
Right.
So.
Okay. Another question, what should I do if there is a serious problem or unsafe condition in my home?
Contact the landlord immediately and let them know of that unsafe condition. Give them an opportunity to resolve it, and if it's not resolved, then you need to contact an attorney and let them know that you need some help.
With many things in this context, documentation I think is so important.
Yes.
Even delivering a letter to the landlord that's going to ultimately be in your file at the apartment complex or at the landlord's place of business that documents the issues that you've raised, I think are critically important if it gets to the stage of having to go talk with a lawyer or somebody else.
So maybe a paper trail, maybe just kind of whenever something needs to be repaired, zip them an email, and that's the way just kind of keep up that communication is underway, something like that.
Right, and I would say in my experience, that's one of the main problems that tenants have. They don't keep a proper paper trail.
Yeah.
So
And
it's very important.
And I would bet folks, they may make note of it, but that versus some sort of correspondence, I would think a correspondence back and forth rather than just noting I called
Right.
on a notepad.
And sometimes, Sean, the lease agreement itself will dictate what type of notice you have to provide to them. And so you need to look in your lease agreement too and make sure that you're providing the proper notice. If it says we're not going to accept emails, although sending an email is going to document the issue and provide notice, it may not be consistent with the lease, and you need to remember that down the road.
Okay. Yes. All right. We've got one segment remaining. Time is flying here on the attorneys, but still time for you to get your question to us. You can call, text, or email. Go ahead and get that to us. You can also find the firm Hollis, Wright & Couch on Facebook. Do you know how to post video to Facebook?
Yes.
It's able to do that. You can find them on Facebook, Hollis, Wright & Couch. Just search that. Or Twitter, Hollis_Wright. Stay tuned. Our final segment of the attorneys coming right up.
From all of us at Hollis, Wright & Couch, we're proud to team up with Alabama's 13 to present the attorneys each Sunday night. Our goal? To answer your tough questions and provide legal support when you need it the most. Remember, you can call, text, or email us your legal questions anytime. This week's topic relates to landlord-tenant law in Alabama. Here are the facts you need to know and what you should do if you or someone you care about is involved in one of these cases. First, always inspect the premises to make sure everything is in good working condition before deciding to move in. Second, read the lease to make sure the agreed upon terms are clearly set out prior to signing the lease. Third, watch out for wording that asks you to give up your tenant rights. Remember, the landlord can't make you sign something that relieves the landlord of his obligation to provide you a livable dwelling. Fourth, if you think your landlord is breaking your lease or violating the landlord-tenant law, call a lawyer right away and don't delay. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis, Wright & Couch want to answer your questions about real issues.
One of the things you learn just by watching this show. A few minutes remaining in this show, but would really like to encourage you to go ahead and get in touch with us. If this topic or another topic of interest to you, just get that question into us, and we will do our best to get our panel of experts to answer that for you. And Sean, the firm fact there about the locks cannot be changed, have you ever heard of that happening in the real world?
Yes. Unfortunately, that happens quite a bit.
Really?
And a landlord cannot just change the locks to evict you. There is a court process that has to be followed. And if they do that, then it's an unlawful eviction, where the tenant, in fact, may be able to seek remedies against the landlord if that's done.
Yeah, and power. You know, the landlord can't just, without a court order, shut your power off or shut your water off, those types of things. Now, the power company can if you're responsible for it and you don't pay it. But point is, the landlord cannot make a circumstance worse because you're having trouble paying rent by turning the power off, those types of things. They've got to go through a set procedure and process. And this is really what you and I see more than anything when these cases come up.
Right. The landlord must give a tenant a notice that they have violated the lease, and after that time period, then they have to be served with an unlawful detainer or an eviction,
right,
which is with the summons and a complaint. And the tenant has usually 7 days to answer if it's for failure to pay rent. And in that instance, you would need to contact an attorney fairly immediately to protect your rights, so that you can file a response to that unlawful detainer in a timely manner.
Can you get yourself out of it once the process is started and initiated to evict you? Let's assume you get paid and you have an opportunity to try and pay back rent. Do you have the ability to try and work with the court and work with the landlord to do that?
Yes, that's a good question. If the landlord is willing to accept rent, then the lease can be reinstated and that process can be stopped. But the landlord does have a right to not accept those rental payments and proceed with the unlawful detainer or the eviction.
Kind of goes back to communication. You know, we talked earlier in the show. Idea, I think, is not just communicate with your landlord on the front end, but is to make sure that you are communicating throughout the entire time. And I think you'd advise this, if you're running into a crunch and a problem, communicate with your landlord.
Right.
Granted, your landlord may be strict and say, we're going to comply with the terms of this lease or I'm going to evict you, but it never hurts to try and work with a person and say, look, I'm going to try and make this right.
Right, and I think landlords do appreciate that, and I think it's especially when you have an individual that owns property, and I think they're a little bit more willing to work with tenants if you're just a little bit upfront and letting them know that you intend on following your contractual obligation.
Just a couple of questions I want to get to, both dealing with evictions. Can a landlord evict me from my home, and what do I do if I receive an eviction notice?
Well, what you need to do first is contact an attorney, I believe, so that you can go ahead and timely respond. As I stated before, typically you have 7 days to respond to an eviction, so you need to go ahead and contact an attorney and let them help you respond so that your rights are protected there.
Okay. Just enough time for a final thought from you all. Sean, a final thought on this whole tenant-landlord right issue?
Well, I would say make sure that you keep a proper paper trail before you sign a lease. Make sure that you're following the lease, your end of the deal once you enter a lease agreement. And if you have any problems, you need to contact an attorney.
I think that's great advice. I would also like to mention something we didn't talk about. Accommodations for disabilities. If for some reason somebody has a disability, blindness, deafness, need for a wheelchair, communication with the landlord's required in those circumstances, knowing on the front end if those accommodations are available, and there are circumstances where the landlord has an obligation to make sure those accommodations are there. So that's an issue we didn't touch on. I think it's important for people watching. At the end of the day, I agree with Sean. Communication and paperwork, those are the keys from the front to the end, and know what you're signing. Don't just sign a lease agreement for the sake of signing it. Make sure you know what you're signing.
And we have 1 minute left, but of the top of the list of what you all run into, have we hit on those tonight, or is there anything we've missed?
I believe so. I think that what I hear most often is I've been unlawfully evicted, my things are set outside,
Right.
or I didn't even know that I was in the lease term, reading the lease agreement. So I have a lot of people don't even know how long their lease term is for until I actually ask them,
Right.
may I see a copy of your lease? So it's just very important to read.
That's what we see too. We generally, unfortunately, as lawyers, don't see issues on the front end a lot.
Right.
People don't come to us to negotiate a lease agreement for a residential lease. It's when there's a problem in the agreement, and 9 times out of 10, lack of good communication between the landlord and tenant is what's caused that issue. Sometimes there are exceptions, but that's generally what we see.
Good stuff. Hope it was helpful to you. Some good information. Sean, thanks so much for being with us. Josh, you as well. And thanks to you as well. Appreciate you spending the time with us. And remember, you can call, text, or email your questions to us 24/7 to the firm of Hollis, Wright & Couch. Find them on Facebook. Just search Hollis, Wright & Couch. And also on Twitter, Hollis_Wright. Thanks for the time tonight. We'll look for you next week right here on The Attorneys.